please. Next case we're going to hear is United States versus Jones. Who's going to argue? Ms. Braga, you're going to introduce?
Your Honor, Stephen Braga,
yeah.
of the Appellate Litigation Clinic at the University of Virginia School of Law.
I need the one I had in the notebook. Caitlin took the notebook.
Satisfied all the requirements for student practice before
We'll get it.
and who has the consent of the client to argue this appeal this morning.
All right, Ms. Mao, welcome, and why don't you approach the bench and make your argument.
The most important question is, did you watch the game?
Which one?
The championship game.
Of course.
All right.
Who won?
Virginia. Of course.
And they were playing who?
Duke.
An inconsequential team.
All right, you may proceed.
May it please the court. Good morning, Your Honors. My name is Corrine Mao, and I represent the appellant in today's case, Mr. Torrance Jones. 3 years of a man's life is not a trifling thing. That was this court's observation in United States v. Ford. Yet here, the consequence of the miscarriage of justice is nearly double that time frame, 5 years and 8 months. This court should reverse the lower court's determination that Mr. Jones' petition is untimely and remand for an adjudication on the merits. This court should find Mr. Jones' petition timely for 2 reasons. First, because the Supreme Court's recent decision in
Timeliness the only issue that we consider here?
Yes, Your Honor, it is the decision, is the decision that the district court issued and the issue on the certificate of appealability.
So if we find it's unnecessarily successive, nonetheless, that's an alternative basis we can consider?
Your Honor, this court may consider that issue. However, with regard to the 2012 petition, the issue of second or successive was, as I stated, not within the certificate of appealability. In addition, the district court below assumed without deciding that this petition was not successive, and therefore the issue has not been fully briefed. And if Your Honors would like additional briefing on that or a remand to the district court for consideration on those grounds, we would be happy to do so. However, with respect to the timeliness issue,
Let me see if I can't get to the nub of this then. It's untimely by statute. It's about 3 years late. But if you can get relief from McQuiggan, then on actual innocence, then you have a new rule. It was within, well, the November 6th one was within the timing, right?
that is correct, Your Honor.
And so you rise and fall with the application of McQuiggan?
That is correct, Your Honor. In this case, we are considering whether McQuiggan, and most notably the framework that the Supreme Court considered in determining an actual innocence exception to the statute of limitations.
Take this one step further, and this narrows it down a little bit more. McQuiggan involved actual innocence on conviction. And your argument is that you would like to apply McQuiggan based on innocence with respect to sentence, not on the conviction.
Yes, Judge Niemeyer.
And we have 3 cases where we have used the innocence on sentence to forego procedural defaults.
Yes, that is correct.
But we've never extended a statute, a congressionally made statute with sentencing innocence. Is that right?
That is correct, Your Honor.
So what you're asking for is basically an extension of McQuiggan, which deals with guilt innocence, to sentencing innocence.
Yes, Judge Niemeyer.
Okay.
McQuiggan, although as you noted, does deal with an actual innocence of conviction, we believe the framework of that case can be applied to this circumstance. Namely, in McQuiggan, the Supreme Court recognized that federal courts have a traditional equitable role to play in habeas proceedings that is not circumvented by AEDPA in the actual innocence context. And in this court, the actual innocence of sentence has been recognized in the cases of Maybach, Michelhunas.
You claim an actual innocence in both of these underlying cases?
One of the vacators was vacated for actual innocence. The other was
You're
not.
not claiming actual innocence then in what, the 2004 one?
The 2000 vacator.
That's the one you say was actual innocence?
Oh, no, I'm sorry, Your Honor, I misunderstood. The 1994 conviction was vacated in 2008 on factual innocence.
And that's the one you say is actual innocence?
That's correct, Your Honor.
What's your basis for saying that?
The Florida Supreme Court vacated on the grounds that there was insufficient evidence
But
in that
that's
case.
irrelevant. I mean, those cases are out. You get the benefit of the fact that they're out. But the only way those two cases affect the drug conviction in this case is to reduce the sentence. It doesn't. You can't claim actual innocence in the drug conviction. You don't, right?
That is correct, Your Honor.
Okay,
However,
so the question is whether if you have innocence in this case with respect to part of the sentence, whether McQuiggan gives you that benefit to change the deadline created by Congress.
precisely, Judge Niemeyer.
Okay, so it doesn't matter whether the Florida was innocent or not. They're out. They're legitimately out. Florida has knocked out those antecedent crimes, and you want the benefit of them. And they knocked those out back in 2008.
Correct, Your Honor.
Okay.
And the implication of those vacators is that Mr. Jones' criminal history category falls from a criminal history category 3 to a criminal history category 1, and that is a difference of nearly 6 years on his sentence.
I thought the sentencing ranges actually overlapped a little.
They do, Your Honor.
Advisory ranges overlapped.
That is correct, Judge King.
So he couldn't get the same sentence.
That is correct, Your
Doesn't
Honor.
necessarily give him 6 years off.
That is true. However, in Maybach, which is this court's seminal case with respect to actual innocence of sentence cases, this court recognized that and granted relief in that case, despite the fact that there was a 20-month overlap in the original and revised sentencing guideline ranges. And so therefore, this court's decision in Maybach forecloses the line of argument that the overlaps do, in fact, are dispositive.
But following Maybach and Michelhunas, in reference to Maybach, it set out Maybach as allowing this limited category of actual innocence of sentence claims only for career offender offenses. And it was very specific in saying that otherwise the actual innocence exception would swallow up the general rule. So why wouldn't Michelhunas control this case?
You are correct, Judge Agee, in that that is what Michelhunas stated. However, we must recognize that the other habitual offender provision, as interpreted in Michelhunas and as applied in Mr. Jones' case, only affects the criminal history category. And therefore, that takes out the whole line of cases.
Tell us how there's a habitual offender provision at play here.
Your Honor, Mr. Jones was sentenced under Sentencing Guideline 4A 1.1, which increases the criminal history points on the basis of prior convictions. And therefore, in that respect, the purpose and effect of these guideline provisions all seek to increase a defendant's...
What's that got to do, though, with ACCA offender conviction or when they proceed under the other guidelines that discuss habitual offender? I mean, it seems like to me this would apply in any case where there's a prior conviction.
Well, Your Honor, it is true that in any sentencing, you must take into account, the sentencing judge would take into account both the base offense and criminal history. However, as recognized and as were the facts in Michelhunas, if a defendant is seeking a reduction in his base offense level, that would not qualify. And that is not what Mr. Jones is seeking. Mr. Jones's case, in contrast, deals only with the criminal history category.
Well, that's my point there. Tell us why with the position that you advocate here wouldn't affect every criminal case where there's a sentencing consideration under the guidelines, even post-Booker. If there's one conviction, it seems like to me that your case would expand McQuiggan to cover them all.
Your Honor, with respect to the floodgates concern...
How is that true?
No, Your Honor, it is not. For two reasons. First, because there still must be an underlying vacator on factual innocence grounds. And this is an exceptionally rare case, as was recognized in McQuiggan, by the Supreme Court in McQuiggan. And because the actual innocence of sentence, as recognized by this court, requires a factual innocence vacator that severely limits the number of cases that this rule or extension would impact.
You're linking the two sentence innocence from conviction innocence, offense innocence. And the Supreme Court in McQuiggan seemed to suggest that the whole basis for that is that we don't want to have somebody who's innocent in jail. And they apply it on the basis that a jury would not have convicted them. And they don't extend that. You have a statutory exception, a limitation imposed by Congress. And when a court comes to extend that on the basis of McQuiggan, it seems to me we can't go any further than McQuiggan goes. And the justification of McQuiggan was the incarceration of innocent people.
Yes, Your Honor.
And which is a far cry. As a matter of fact, I think it was Justice Scalia, didn't he point out the distinction between that and procedural defaults, where we have applied the innocence of sentence. The wrong sentence, basically. That's what it comes down to.
Correct, Judge Niemeyer. However, in either case, with respect to either innocence of conviction or innocence of sentence, as recognized by this court's precedents, there is an underlying actual innocence, a factual innocence case. And in that respect, the line between what was recognized in McQuiggan and Mr. Jones' case it diminishes. Because Mr. Jones' underlying vacator was vacated on factual innocence grounds, the imperative is there in both cases.
What factual innocence?
Your Honor, the 2008 vacator was granted on the basis of an affidavit indicating that Mr.
But
Jones...
that has nothing to do with it. Those cases are out for whatever reason. That doesn't get rid of his... He was convicted of drug trafficking in 1996. That's a serious federal offense. There's no vacator for that. He's in jail properly, convicted by a jury. The only issue in this case is his sentence proper.
That's true, Your Honor.
Based on the vacation of two convictions in Florida that enhanced his sentence. Now, when you knock out those Florida convictions, then you're going to get a lesser sentence in the drug conviction case. But we don't have any actual innocence of fact on the guilt here.
That is true, Your Honor. However, in the Supreme Court case of Day versus McDonough that came out in 2006, the Supreme Court recognized that procedural bars, including procedural default, as well as statute of limitations, should be treated similarly. And that is because they are all
One's created by Congress and the other's created by the courts. Congress set the one-year limitation statute in the statute, whereas the procedural default is court-made.
That is true, Your Honor, and that is precisely where...
And we can give and take away, right?
Yes, Your Honor.
Yeah, well.
That is precisely where McQuiggan does the work and comes into play in this case. Because in McQuiggan, the Supreme Court recognized the traditional equitable role of federal habeas courts and the fact that this court has already recognized a long-standing actual innocence of sentence claim, this does not, in fact, circumvent AEDPA's statutory role. In this court, the actual innocence of sentence claim was recognized even before AEDPA was passed. In fact, it goes back and has not been questioned in this court. And therefore, because Mr. Jones's claim is an actual innocence of sentence claim, it falls squarely within the authority of this court to consider.
I thought you had made, I may be wrong, but I thought you had made a separate argument apart from what we've discussed so far, where in essence you argued that there should be an equitable tolling that related to a prior habeas petition. Is that, did I make that up, or is that an additional argument that you made?
Yes, Judge Agee. In the informal briefs filed before this court by Mr. Jones when he was pro se, he did argue equitable tolling.
Well, do you?
Your Honor, we did not brief the issue in our opening briefs, and for that reason, we do not argue it today. However, if Your Honors would like supplemental briefing on that issue, we'd be happy.
All right.
Your Honors, not only can McQuiggan's framework be applied to apply the actual innocence extension in Mr. Jones's case, he fits within this court's actual innocence of sentence.
Do you see a qualitative difference between someone who's in jail for a crime he did not commit and a person who is in jail for a sentence longer than he should have been?
In name only, Your Honor. And that is,
Name only?
yes, and that is because,
I mean, in the second case, the man is in jail because he committed a crime. Whereas in the first case, he's innocent and shouldn't be in jail. Now, sure, he's innocent of part of his sentence, but it seems to me that is not as serious a problem as what the Supreme Court identified in McQuiggan, is that we shouldn't have the innocent people in jail.
well, that is correct, Your Honor. However, we're not asking that Mr. Jones be released on the basis of his underlying federal conviction. He will do the time for the crime that he committed, and that is unequivocal.
Well, I understand your argument that he's over-sentenced, he's serving too long, but he had a way to solve that, and the statute gave him a way to solve that, and he didn't avail himself of the time periods given by the statute. So now the question is, do we go back and relieve him of that failure because he's serving too long a sentence? Now, the Supreme Court in McQuiggan says we will relieve him of a time period if he shouldn't have been in jail at all.
That is,
And I think that's a difference, don't you think?
yes, Your Honor. However, this court, in announcing the actual innocence of sentence exception in Maybach, recognized that that jurisprudence flows directly from Sawyer, which is the Supreme Court case. And in that instance, because actual innocence of sentence claims are cut from the same cloth as of the type that was recognized in McQuiggan, that is why actual innocence of sentence does apply here.
All right, thank you very much.
Thank you, Your Honors.
You've reserved some rebuttal. We'll see you.
Yes, Your Honor.
All right. Ms. Shaw.
May it please the court. Good morning. I'm Shalka Shaw, and here on behalf of the United States. The defendant here has talked about innocence a whole lot before this court. Let's be clear. This defendant is not innocent. He is a man who distributed over 100 kilos of crack and cocaine. He was properly and lawfully sentenced as such. Now, Section 2255 only provides defendants a limited ability to attack their conviction and sentence. There are three specific statutory limitations encompassed in Section 2255. First, it limits the subject matter on what is cognizable in a Section 2255 proceeding. Second, it imposes a statute of limitations. And third, it bars second or successive motions except in limited circumstances where the defendant has presented newly discovered evidence that demonstrates by clear and convincing evidence that a reasonable fact finder would not have found him guilty of the crime, of the offense of conviction, or where the defendant presents a new rule of constitutional law that applies to his conviction and has been retroactively applicable to his conviction. He fails all three of these statutory limitations. In March of 2012, he filed a Section 2255 motion. This was his fifth Section 2255 motion. It was also his fifth time since the November 2008 vacatur of his 1994 conviction, the fifth time raising that claim before the district court. And all five of those claims were denied. All five of those claims came before the Fourth Circuit, and the district court was affirmed in every one of those cases. The defendant's petition is successive, and we point out that the court may affirm for any reason that is supported by the record. This petition was successive, and the district court should have dismissed it for lack of jurisdiction. This petition is untimely. Under Johnson, the Supreme Court told us that he had 1 year from the state court vacatur to file a timely motion based on that vacatur. His 1994 conviction was vacated in November of 2008. He did not file this motion until March of 2012. This motion is not timely, and there is no exception to that. Finally, his claim is nothing more than a quintessential guidelines application claim. He is challenging his criminal history category. He is trying to be sentenced with a revised advisory guideline range that would result in overlapping.
He did have facts that revised his guideline, and that was the vacation of the 2 Florida convictions.
Yes, Your Honor.
And your argument, I gather, that happened in 2008. And I gather your argument is that he should have taken advantage of that promptly.
Well, and I will point out to the court that he did take advantage of that within 1 year. He did file what we acknowledge was a timely motion in November of 2009 based on that 2008 vacatur. But that motion was successive. And there has been no articulation from the Supreme Court.
That was his Rule 60B motion?
Well, he filed 2 motions. So in November of 2009, he filed a motion in the Southern District of Illinois. It was a habeas corpus motion. And that motion was...
2241.
It was a 2241. And that was transferred...
Are you counting that as a 2255 when you say he's filed 5 of them?
Well, it was ultimately treated as a 2255. It transferred to the Eastern District of Virginia. Eastern District of Virginia construed that as a 2255.
And that was the time he first claimed that he was actually innocent.
Yes, and that was the only timely motion that he filed, claiming this, raising a claim based on the state court vacatur of his 1994 offense that was included in his criminal history category. But that motion was successive. He filed a Section 2255 motion in 2001, within a year of when his state court conviction was final. In that motion, he raised 8 claims for relief. He didn't raise this claim, and...
Well, he couldn't have raised it then.
Yes, Your Honor. Well, arguably, he couldn't have raised it. He didn't have the state court vacatur in hand at that point.
No, he filed one in October of 2000.
Yes.
And there, he still had the Florida convictions, and his sentence was appropriate.
Yes, at that
In
point.
2008, he got rid of the Florida sentences, Florida convictions, and so that impacted his sentence in this case. And he filed, within a year of that, he filed a 2241.
Yes, Your Honor, that's correct. But in 2000 is when he began,
So that one was timely.
His 2001 motion,
No, the 2009.
it's arguably timely. It was filed within 1 year of the state court vacatur. But again, as we raised an argument in our brief, that under Johnson, he also was required to diligently pursue the
Due
state court
diligence is
vacatur.
required under Johnson.
Exactly.
If
And
you raised that, you say it wasn't diligent?
yes, Your Honor, we do argue that it was not diligent. He had his
Well, he
state
filed
court...
it within a year.
I'm sorry, a year of what?
Well, he filed it within a year of that his conviction was vacated in Florida.
But Johnson requires diligence in pursuing the state court vacatur. And they measure that date of diligence from the date of his federal judgment. His federal judgment was in 1997.
So you that due diligence doesn't come into play from the time that his underlying conviction is vacated down here in Florida.
No, Johnson imposed 2 requirements to treat it as timely. One, it had to be filed within 1 year of the state court vacatur under 2255 F4. But it also required that the defendant pursued the state court vacatur diligently.
When did he initiate the procedures to get rid of the state court?
He filed both habeas petitions on the 1990 and 1994 convictions in 2001, which was 4 years after his federal judgment in 1997. In Johnson, we dealt with less time. They had filed, I think it was about 3.5 years.
I'm missing the sequence here.
So
He got a vacatur in Florida. The last one was November 7, 2008.
yes, Your Honor.
When did he initiate that proceeding?
So speaking to the 1994 conviction, he filed a motion in March of 2001
Okay,
seeking to
2001,
vacate that
right.
conviction, which was 4 years after. That motion was actually denied in November of 2001. That motion had included the affidavit of James Moore that the defendant spoke to today. That motion was denied in November of 2001. Then in March of 2008, he refiled a habeas petition challenging that 1994 conviction. Now, just to have the timeline right, that's 11 years after his federal judgment. In that, he included the Moore affidavit and included newly an affidavit from his trial attorney saying that he hadn't advised him as to the actual charges he was facing at the time of the plea. Now, with those 2 affidavits, the Florida court then vacated the conviction in November of 2008. So arguably, he didn't file his successive motion until 11 years after his federal judgment. So while he did come in under 2255F4, we do maintain that under Johnson, there's a question as to whether or not he was diligent in pursuing his state court vacatur.
I understand the argument now.
Okay. Now, that petition was, that November of 2009 petition was dismissed as successive. The defendant appealed that to the Fourth Circuit, and the Fourth Circuit affirmed that decision, finding that he did not fall into either of the limited and narrow exceptions in 2255H. A couple years later, he then again files a 2255 motion, asking the court again to consider the 2008 vacatur of his 1994 conviction and to re-sentence him with a lower advisory guideline range. This motion is...
All these things are pro se.
Not every motion he filed was pro se, but his 2009 motion was pro se and his 2012 motion was pro se. He did have lawyers at intermittent times throughout his various habeas filings or post-conviction filings.
After he got his relief down here in Florida, everything was pro se.
He had representation in Florida.
No, but after Florida.
Oh, yes, except
Federal
there...
court, everything was pro se.
Well...
Since 2008.
In June of 2009, he filed 2 motions with the assistance of an attorney in the Eastern District of North Carolina. Those 2 motions were 3582C, and he also filed a motion to correct the PSR based on the 2008 vacatur. They ended up withdrawing that motion to correct the PSR and only pursue the 3582C. He did have counsel on those. Everything else...
Sound like he's pretty diligent. Yes.
I would argue that he's very persistent, Your Honor. He has been persistent. Since 2008 to 2012, he filed, the 2012 motion was his 5th motion. So
What's his sentence for the drug trafficking in this case?
360 months, Your Honor.
30 years?
30 years. Now, I do want to address something that Judge Niemeyer addressed.
And even if this thing goes back to Category 1, he still can get 360 months.
Yes, Your Honor. 360 months would still be...
He says that's not relevant.
We argue that it is relevant, because when we're looking at
You do
what...
say it's relevant.
Yes.
That the guideline ranges overlap.
But the guideline ranges overlap and include the sentence that he did receive. And if he were to reduce to Category 1, they would overlap. We argue he's only entitled, for purposes of this appeal, to consider a reduction down to a criminal history 2. Now,
what would the argument be that it's relevant? Is it that he doesn't have sentencing innocence because his sentence still falls within the guideline range?
Yes, Your Honor. Looking at what's a cognizable claim for relief, when the courts have looked to what constitutes a fundamental miscarriage of justice, such that it would be a cognizable claim for relief, a guidelines challenge does not rise to that level, especially, and the courts have said, especially in the case where the defendant could have received the exact same sentence, even if this were remanded back to the district court.
I thought your position was that as far as these actual innocence of sentence claims was that in effect there's a bright line rule, at least in the Fourth Circuit, that if it doesn't involve a career offender provision or a habitual offender provision, that's it.
Yes, Your Honor, that is our position. In all of the cases in the United States Supreme Court and all of the cases in the Fourth Circuit.
You're shooting with a lot of arrows, right?
Yes, Your Honor, we are. We're shooting with a lot of arrows. First, starting with McQuiggan, they talk about actual innocence of the offense. Now, they also talk about an actual innocence of sentence enhancement.
Now, which offense are you talking about? Actual innocence.
In McQuiggan, as applied to this case, that means the defendant would have to say that he is innocent of the drug trafficking convictions. And
when he's in federal prison on.
Exactly, and they make no claim.
He's actually innocent of the Florida offenses, doesn't help him out.
No, Your Honor. It does not have, and McQuiggan has no applicability to that. However, I do think that the dissent in McQuiggan is very telling. McQuiggan was the first time that the Supreme Court drew an exception to the statutory limitations under 2255. And they drew it for a very serious situation where someone who was in prison were they're actually innocent of the crime. The dissent strongly disagreed with that approach, but it's very telling that in the situation where a defendant who is not innocent of his crime and makes no claim to be innocent of the actual crime for which he was convicted, was properly and lawfully sentenced. His sentence is still within the advisory guideline range that he would receive if this case were remanded. For the Supreme Court to take that, for this court to take that step and extend McQuiggan, that's a few leaps, Your Honor. And I don't think McQuiggan or any of the case law from the United States Supreme Court or the jurisdiction of this court would support taking any exception to that level. Now, the defendant does cite to 4 cases from the Fourth Circuit: Pettiford, Gadsden, Maybach, and Michelaujunas about...
They procedural defaults, right?
Exactly, Your Honor. So there are 3, statutorily created exceptions, which we talked about: subject matter, statute of limitations, and successive petitions. Procedural default is a court-created doctrine. Now, the Fourth Circuit has created an exception to that where you're actual innocent of your sentence. Now, we do argue that he's not even actually innocent of his sentence as under the Fourth Circuit specific exception there. 1, he would have to show that he was factually innocent of the underlying conviction. 2, that conviction was used to enhance him as a career offender or under another habitual offender provision. And 3, that he suffered prejudice as a result. This is where the defendant talks about whether or not he's factually innocent of the crime at all. Again, I think any argument that he's factually innocent of the 1994 Florida conviction is speculative at best. Like I said, the Moore affidavit was included in 2001. The Florida court rejected that habeas motion. Then he included the same affidavit again in 2008 with a new affidavit from counsel about whether or not his plea was intelligent and voluntary. Then the Florida court vacated it. Any argument that this was a vacatur based on factual innocence is speculative.
But you say that a vacature based on factual innocence doesn't make any difference. I thought that's what you said.
Well, I'm speaking right now to the actual innocence of sentence exception. I don't think that exception applies to this case. I think in this case, we're dealing with a state court vacatur. And under Johnson, I make the argument that he's not timely. Am I understanding Your Honor's question correctly? I think I may have missed it. Under the second prong of the actual innocence of sentence exception in the Fourth Circuit, that's where we make the argument that this has only ever been extended in the career offender and armed career criminal context, except in Michelaujunas, where they chose not to extend it, because in that case, we were dealing with an enhancement to the defendant's base offense level. This is a similar situation in Michelaujunas. Here we're dealing with one with a increase in the defendant's criminal history category. These aren't the types of situations that Michelaujunas contemplated. The situations where the defendant is sentenced, his sentence is significantly enhanced based on him having a specific number of a specific type of predicate state court convictions. In an armed career criminal context, he's getting a heightened mandatory minimum, his base offense level is going to be higher, and he's getting a heightened criminal history category. Similarly, in the career offender under 4B1.1, it's affecting his criminal history category and his base offense level. This defendant was not sentenced as a recidivist. He was not sentenced. His sentence was not driven by his criminal history category. It was driven by the large quantity of drugs that he distributed into North Carolina. Your Honors, we argue that the defendant's motion is procedurally barred, and he cannot get around this procedurally barred, that there is no authority to extend any exception to the situation we're presented with today. Accordingly, we ask that the court affirm the district court. Seeing that there are no questions from the panel, thank you very much.
All right, Ms. Mao.
Thank you, Your Honors. First, with respect to the panel's questions on actual innocence of conviction versus sentence, the core fundamental tenet under both of those claims is that a defendant would be serving time in prison that is undeserved, and that is not in dispute in this case. Mr. Jones has 2 underlying state court vacators that would reduce his sentence, and therefore he is prejudiced.
Do you think that Congress would be without authority to impose a limitation on challenging an illegal sentence?
Of course not, Your Honor. That would be within Congress's prerogative.
It's within the rules, it's within the statute, and it's within the habeas. All of them establish deadlines or challenging a sentence that's too long.
Yes, Your Honor. However, it is important to recognize that in McQuiggan, which dealt with 2244, that was also its statute. And in McQuiggan, the Supreme Court said that there was an equitable exception.
In McQuiggan, Supreme Court recognized it was a statute and that it was providing an exception to something Congress did, and it required actual innocence. It said they spent, I think, 2 or 3 times said, we do not want innocent people in jail, and that this demand for justice was enormous. Now, you can make the same argument that an overstated sentence is also a demand for justice, but Congress addressed that separately and did impose deadlines on it, and the Supreme Court didn't address that issue. If we were to extend McQuiggan to sentencing errors, it would be a pretty bold Fourth Circuit to do that, right?
Your Honor, the Fourth Circuit would be the first circuit to consider that. However, because the circuit has previously recognized actual innocence of sentence and recognized that the actual innocence of sentence flows directly from actual innocence jurisprudence, and the power of the federal habeas courts in that respect.
But we never use the actual innocence of sentence to violate a congressional statute deadline. In other words, the deadline under Rule 35 and 3582, whatever number that is, and the habeas, we've never barreled through one of those deadlines that Congress created based on sentencing issue. All we did is forgave procedural default.
Yes, Your Honor. However, with respect to that, Sawyer recognized the exception with respect to second or successive petitions. However, if this court, the statute of limitations. However, if this court were to restrict McQuiggan purely to actual innocence of conviction claims, in effect, no Sawyer-based
We
claim.
wouldn't be restricting it. That's all it helped. We would have to extend it.
Your Honor, that decision was not before the Supreme Court, and so therefore there has been
Well,
no.
We're talking about the McQuiggan case.
Yes, Your Honor.
That's before the Supreme Court.
That
You
was.
want us to extend it.
We believe that the framework can be
You
applied.
have to want us to extend it, I think.
Yes, the framework can be applied with respect to actual innocence of sentence, because actual innocence of sentence has already been recognized and has been since 1994 in this court.
Thank you.
Thank you, Your Honor.
I want to recognize that, Mr. Braga, you were court appointed, and that's really an important service to the court. And Ms. Mao, your service in connection with the program at University of Virginia, you did an excellent job. Your client can be proud, and we'll come down and greet you and proceed on to the next case.
Thank you, Your Honor.